In the complex litigation system, disputes over electronic evidence are considered especially heinous. These disputes are resolved by two separate yet equally important groups: the technologists who investigate the data and the attorneys who argue the merits in court. In electronic discovery, the dedicated consultants who analyze and investigate the data are an elite team known as the project advisors. These are their stories.
All right. I'd like to thank everyone for joining us today for our Law and Order Discovery Dispute Unit, Episode 4, Social Media Distancing. It's Peter Florek versus Diane Lockhart. For those of you who have not had an opportunity to look at the case facts, we'll take a brief look at those. So the plaintiff is Peter Florek. He's a semi-professional basketball player who is suing over personal injuries that he received after a fall from a horse. The defendant is Diane Lockhart. She's the owner of a successful horse ranch, which is where the plaintiff fell from the horse. She's been sued previously for failure to take appropriate safety precautions at the horse ranch. As a result of some of those prior suits, she placed a security camera facing the area where customers would ride the horses. The plaintiff filed suit against the defendant for the injuries he suffered, his inability to continue playing semi-professional basketball, and other damages. The plaintiff learned during the discovery that the defendant had been previously sued for alleged safety violations at the ranch and had created new accounts on social media to suppress negative reviews, and also paid Yelp to do the same. The defendant has requested the contents of the plaintiff's Facebook account. The plaintiff claimed that they were unable to access their Facebook account because they lost their cell phone where the password was on autosave, and they would never be able to recover that password. The defendant was able to locate a private Facebook account with the plaintiff's name spelled backwards that was created at the same time their original Facebook account was inaccessible. The defendant has also located some videos of the plaintiff where he was tagged playing basketball and giving motivational speeches. The plaintiff has filed a motion to compel the production of the defendant's social media accounts, their agreement with Yelp, and the footage of the security camera. The defendant has requested the full contents of the plaintiff's Facebook account, including private messages. Today we're deciding three issues. Should the court grant access to the plaintiff's complete Facebook account, including messages with timestamps through the Facebook messaging function? Should the court grant access to all the defendant's Facebook, Twitter, and Yelp accounts, including the accounts that were previously closed down or deleted? And should the court grant access to the defendant's contractual agreement with Yelp and the information from the security company? Today we have joining us, the role of judge will be played by Amanda Cook. We also have Chad Roberts, who is Discovery Counsel at eDiscovery CoCounsel. And we have Matt Wessel, who is Litigation Support Director at Thomas Coburn. And with that, I will turn it over to Judge Cook to get us started.
All right. Hello, everybody, and welcome. I'm going to have the plaintiff argue first, and then we'll hear from the defendant. Chad, we can't hear you. Matt, would you mind jumping in so Chad can figure out what's going on with his audio?
Sure, that sounds good. Can you hear me fine?
Yes.
Can you hear me? Okay.
Yeah.
Hi, I'm Matt Wessel. I'm representing the defendant. So basically, I wanted to walk through these sort of three groups one by one. First of all, the plaintiff's Facebook account, which we are seeking the records of. Second, the defendant's request for our Yelp materials, and then the defendant's request for our other social media accounts. And also, I should add in a request for the video footage that's in the possession of a security company we contracted with. So the plaintiff is alleging that he had certain physical and mental incapacities, and during the course of discovery, he claimed that he was no longer able to access a Facebook account that he had prior to and up to the time of the injury, that he lost his phone, that the password was auto-saved. There is no evidence that he sought access to it by contacting Facebook and asking for a password reset or anything. Along the course of doing our due diligence, we discovered that the plaintiff did have an active Facebook account that was his name spelled backwards, and we located some public photos of him that were posted to Facebook by another individual, and he was tagged in them. And of course, we also found some videos of him some videos of him giving public speeches apparently after the incident. So the rules of civil procedure at play require the production of material information that is, of course, material to the plaintiff's claims of mental and physical incapacity, and we believe that these materials on his current active Facebook account go directly to that, to his capabilities after the incident. These materials are not immune to discovery under any sort of policy considerations. And while there used to be sort of a heightened threshold, when Facebook and social media accounts were rather new, there was a heightened threshold to accessing these materials, but that's no longer at play. So as to the photos that were tagged by someone else, the plaintiff would have access to these photographs, and he is in the best position to provide them to us. It will be onerous on the defendant to locate the individual who actually posted these photos and potentially subpoena that individual as a non-party when the plaintiff has ready access to those photos. So it really was like two things along those lines. One, we'd like the plaintiff to make a further effort to access the account that was active at the time of the incident. Barring that, we would like to consider filing additional motion for a spoliation claim if he is unwilling to do so. Second of all, we would request that the plaintiff provide timestamp materials from his current Facebook account. And since he is alleging both physical and mental incapabilities, despite apparently being able to create a new Facebook account, even one rather complicated name with his name so backwards, and him giving public speeches, I think full access to that Facebook account would, sort of be logical and within the bounds of the rules. Because really, anything that can go to proving that he has, full mental capability is material to his claim. In terms of the defendant's request for the Yelp materials, there's no allegation that the defendant, there's no allegation that the plaintiff relied upon Yelp reviews to book his trip or anything like that. So, we believe that those are not material to the claim at issue, particularly the contract and any pre-existing alleged pre-existing Yelp account. As for the Facebook, any sort of Facebook materials that the defendant have that are no longer accessible, I guess I would say that those aren't really material in the plaintiff's claim either. And even if he was granted access to it, it should be limited to the specific animal at issue that caused the incident. The plaintiff has also requested that we provide him with video security video that was taken time of the incident, and he requested that from the proper party, which is the contractor had handled those videos, and that is the issue, for that third party, because they are the one in control of those videos. It's not like the Facebook photos that we can readily access. The contractor is the one that has access to those videos. So basically, in closing, we'd like full access to the plaintiff's Facebook account that shows he has the requisite mental and physical capabilities, because they are material to the issues, and that we should not be required to provide non-material evidence from Yelp or non-material documentation from Yelp or our social media accounts. Thank you.
Thank you, Matt. And with that, we're going to turn to Chad to argue for the plaintiff.
How are we doing this time, Your Honor? Better?
Yes, much better.
Oh, good. Your Honor, thank you so much. We have the privilege of representing Mr. Florek, a young, vigorous man in the prime of his youth and his health, so much so that he was a semi-pro professional basketball player. And the issue that brings us here today is that he was horseback riding out on defendant's ranch. Unfortunately, he was saddled up with a horse that was nicknamed Firecracker. Of course, he didn't know the horse's nickname was Firecracker, but that was apparently a nickname that the horse came by fairly honestly. And he was thrown from Firecracker and suffered very serious injuries. His history is replete with evidence of a lot of folks have been seriously injured by these kinds of accidents. And they're predictable and they're foreseeable. A horse's demeanor and temperament and suitability for people of average horse riding skills to be exposed to is a well-known risk in the commercial horse riding industry. It's very foreseeable. So let's take it in order of what I think will be the easiest for the disposition of Your Honor's consideration. The first is, as is typical nowadays in electronic discovery, where the information in the media is not entirely in the physical possession of the party who has functional control of that information. And so there could be nothing more relevant and nothing more probative than to watch Firecracker's behavior as he transitioned from a mild-mannered horse to doing the behavior that Firecracker was known for, which resulted in Mr. Florek being pitched. So that would begin with the court, which has jurisdiction over the defendant and can control and enter orders directing the defendant's discovery conduct to grant permission for its third-party contractor with whom it's in contractual privity. It has a contractual right to release the information to the plaintiff, and we ask that the court do that. This is a classic possession, custody, or control issue, and in this case, the determining factor is control, which requires a mere demonstration that there is a legal right to direct access to the information. The other, in a similar vein, is more traditional, is the contract that the defendant has with Yelp to suppress evidence in a way. Nothing illegal, perhaps, about hiring a party to create effervescent reviews of your business practice that you don't deserve. But nonetheless, that's how Yelp makes its money. Defendant had a contract, and it will be probative, you know, if that contract says, you know, please pay particular attention to complaints about Firecracker. We don't have any other horses right now, so when we have a busy day, we have to roll him out and saddle him up with somebody. We try to pick an adult, but, you know, we're tired of these complaints about Firecracker. Nothing burdensome about that contract or those communications, and absent of showing that they're burdensome or somehow difficult to produce, we think that should be an easy disposition for the court as well. Again, that involves a contractual right to control that information and the possession of the contract itself. And similarly, Your Honor, with the social media accounts, these are where other people, you know, this whole case is about foreseeability, right? It's about the prior conduct of Firecracker and how many times has he done this. And no better place is likely to have that kind of probative evidence than the social media accounts of the defendant, which in this day and age is something like a real-time running log of a party or an entity or a person's real life. It's the closest we have now to people keeping diaries, which have always been discoverable. So that information was in the public domain. It was nothing private about it. The defendant promoted it through those activities, and we think that should be, as they're asking for Mr. Florick's prior postings of Facebook, we think that should be equally discoverable by Mr. Florick as well. One last issue in closing, Your Honor, is the issue of authentication. The defendant would purport to advance evidence that they found a picture on Facebook on someone else's site where Mr. Florick was tagged with that function of Facebook where you can identify a photograph of someone. There's no evidence about when the picture was taken or the context or what the setting was. And in this day and age, Your Honor, it used to be exotic to do deep fakes, right? It used to be the stuff of spies and governments trying to sabotage other public figures. It's not that anymore. Every high school hacker has AI software that can take an image and deep fake and morph it onto someone else's image. So in the absence of a scrupulous authentication, we think that material should not be admitted or even entertained by the court under those kinds of circumstances. Thank you.
Thank you. And I appreciate the spirited arguments of both sides. I'm going to now issue the rulings kind of in the reverse order that you just did. As to the plaintiff's Facebook account, I am going to order that the plaintiff produce in a forensically collected manner the contents of the Facebook page, including their photos, the posts made to their walls, and messaging timestamps for private messages. The reason for this is the plaintiff is putting at issue their mental and physical well-being, their ability to communicate, their ability to function in society, and posts to Facebook by their plaintiff, by their own admission, frequently posted to Facebook prior to the incident. And so this would go to their state of mind, it would go to their damages, and it would go to their, all the sort of the heart of where the damages are going to come from in this case. And so the court will order that those will be produced, and additionally, the presence of this sort of rival alter account and these photos show that there is activity occurring on Facebook that could be very relevant to the defendant's claims. Thank you, Your Honor. You're welcome. As to the defendant's Facebook, Twitter, and Yelp business accounts, much like with the request for the plaintiff, it's a bit overbroad and not really winnowed down with enough specificity. So the court is going to order any safety complaints made on these pages will have to be disclosed and produced in the 6 months prior to and post the alleged accident. I think that these could be very relevant to the plaintiff's claims as to safety and the things that they're alleging in the personal injury suit. And I will agree with plaintiff on the last point. The contractual agreement, if they are suppressing reviews, does go to foreseeability. And so I'm going to order the production of that, and I'm going to order the third party to produce the video, as that's pretty dispositive if we have captured what occurred that day. So that's my ruling, and thank you both for your arguments.
Thank you, Your Honor.
And so next we're going to go through some recent decisions. So when we write these facts, we base them on a sort of amalgamation of current case law and interesting, fun decisions that we like about different kinds of eDiscovery issues. And Jeff is going to tackle our first one and give you a quick rundown.
So Foreman versus Henkin was a New York case, started with the trial court. It was actually a case where someone was made a claim for an injury after being thrown from a horse. She was not a semi-professional basketball player, however, but one of the claims that she made was for a cognitive related injury, which ultimately led to her deletion or closing of her Facebook account. The trial court did make a limited ruling on a motion to compel some portion of photographs that were not viewable publicly because of privacy settings. There was also a ruling related to some messaging based on the cognition claim. However, the defendant did not appeal that, but the plaintiffs did appeal the ruling of related to the pictures in the private portion of her Facebook page. The appellate division actually reduced the scope and reach of what was needed to be produced, and then ultimately the appeals court reversed that appellate division decision and reinstated the trial court's granting of the motion to compel, but did not address the messaging issue as it was not appealed by the defendant.
And then the next case is, it's my favorite case for Facebook discoverability. The Vasquez Santos v. Matthew. This is the case where we had a semi-professional basketball player who was injured and claimed he couldn't play anymore, and he was, disabled and he couldn't continue. And the defendant in that case found pictures of him playing basketball where he was tagged. He didn't even actually post them himself. And the court ruled that they had a right to look into these photographs and look into his Facebook account, because once it's tagged, you as the plaintiff have access to this information, and you can then have to produce it. And the defendant can use those photos and the timing of the photos to rebut any claims that he has for the extensiveness of his injuries. And I like this one because, everybody posts stuff all the time. And I think the takeaway for this is once it's online, it's discoverable. So be very careful with your Facebook postings. That's my one takeaway. And then the third case is Cordova v. Walmart. And this one, I think a plaintiff fell. I think it was a slip and fall. And she had a social media account, and then she closed it, and she couldn't remember the name that she had the account under. And then she lost her phone with the autosave, and then she tried to log in from her home, and she was locked out. She got a new phone. She tried to get in again and was not able to access it. They investigated a little further. They found her a new profile with pictures and recent activity with her second name and her first name spelled backwards. And that was opened after the litigation had began. And she then proceeded to produce buckets of data from her Facebook account, but not everything. And so the court basically, they didn't dismiss, but they said it did rise to the level of spoliation, all this sort of weird mumbo jumbo with these different accounts and jumping back in and creating new ones and deleting ones. And so they did allow an adverse inference instruction to that party. So that's our case law. I don't know what you guys think. Have you guys come across this in your different practices? Is social media a big thing for what you're dealing with?
We have.
Verbally? I can, and I can tell you the challenge of a forensic collection from Facebook is not obvious. And as you know, Facebook's attitude is, don't even bother with a subpoena to us. It's going to go in a black hole and it's never going to win, and they don't. So it's always driven by this client-driven collection, or a in-user collection, as it will. And those can be a challenge. They're not, right now, they're not traditionally processed or containing the kind of metadata that we're accustomed to in a load file type of a thing. So it's something to plan for ahead of time and get a little help on when it comes up.
Yeah,
I think one of the more fast.
Go
Sorry, go ahead, Amanda.
No, you're fine. Go ahead.
I was just going to say, there really is the most fascinating thing that Facebook is almost, impervious to any of these direct subpoenas to them. It's almost unheard of, in history, that they just have that sort of power. In fact, I think this will be on YouTube later, and I think isn't Facebook on YouTube? So maybe I'm in trouble just for saying this.
Yeah, no, I agree. And I think one of the interesting things that Chad brought up, which I kind of went down a nice rabbit hole yesterday, was authentication and deep fakes and catfish accounts, and how do you know who's controlling what, and if it's actually their account. Like, we've seen all these crazy things happen where it's not in fact their account, it's somebody spoofing them. And so I think authentication becomes a really interesting problem when you're dealing with social media evidence. And yeah, I think my takeaways from all these is just always be really, really careful what you're posting online. That, like, what is it? I think it's email like no one's watching, or email like, I forget what, dance like no one's watching, email like it's gonna one day be read aloud in a deposition. I kind of feel that way about social media as well. So with that, I wanted to open it up to the larger group to see if anybody had any questions, or if they've come across this in their practice. If you agreed with the ruling or you thought it was terrible, yeah, this is kind of an open floor for anybody who wants to talk. And if you want to raise your hand or throw something in the chat, that's fine too. Luke, do we have anybody's any questions?
I'd hope we would do something with Firecracker. I mean, if you could address that animal's a nuisance.
That was a great one.
He's a public nuisance. He's a public nuisance, and it's time for him to go to pasture or something. But this is a great social issue of concern, and I hope you would reserve jurisdiction on Firecracker.
Menace to society, right? I think Chad might have taken some liberty with facts. But all right, well, I'm going to turn it over to Jeff to close. So.
All right, I do want to thank everyone for your time and for being here today. I once again want to thank our panelists. Just a little background on us and our panelists today. Chad founded eDiscovery CoCounsel PLLC in 2013 after a 20-year career as a complex litigation attorney. He has worked both in large multinational firms as well as boutique trial firms, and won multi-million-dollar verdicts as lead trial counsel. In his current role, he focuses on discovery motion practice in federal courts, information governance, analytics, and information retrieval technology, and has both the CEDS and RCA certifications. Matt is litigation support director at Thompson, Coburn. Matt has spent his career as a eDiscovery attorney and solutions provider. He currently oversees all services related to client technology and eDiscovery, and develops and manages firm processes related to document collection, review, and production, as well as the child support responsibilities. and ensures that the firm provides their clients with effective and efficient solutions to meet their needs and requirements. Amanda, our judge, is a senior project advisor here at Acorn. She's a detail-oriented eDiscovery practitioner who has worked in all aspects of the EDRM lifecycle. Amanda's a passionate advocate for the use of electronic discovery to reduce cost and increase efficiency, and has a consultative and customized approach to client services to help clients achieve successful and cost-effective outcome. And Amanda is fluent in translating technical jargon to legalese in plain English and back again. I'm Jeff Hudson. I'm the Director of Professional Services here. Prior to my eDiscovery career, I was a complex litigation attorney. I've also been a project manager and a technical manager as well. I've worked in all aspects of the litigation and eDiscovery lifecycle, and I enjoy coming up with analytical and cost-effective approaches to ensure client success. And with that, I would once again like to thank everyone for being here today, and hope you can join us for our next episode, episode 5, which is coming up in August.